Hello, everyone, and welcome to USPTO Hour, the Trademarks edition. It is February 25th, 2026, and today we are fortunate to have as our guests two trademark experts from our Trademark Operations Division. I'm Jason Lott, the managing attorney for Trademarks Customer Outreach at the USPTO, and it is my job to provide you with legal training in the field of trademarks. Whether you are a small business owner, a new lawyer, a paralegal, support staff, or maybe you're one of our experienced practitioners with decades in the field, we want to make sure that you have the knowledge and the tools that you need in order to accomplish your trademark goals. Specifically, we want to make sure that you are able to submit the highest quality application that you can, and of course, avoid trademark scams. So, as you can see on the screen today, we have a great lineup of experts, including the Acting Deputy Commissioner for Trademark Operations, as well as one of our senior attorneys for one of our law offices. And I'm going to introduce them in just a moment. But before I do, we have to hit a couple of really quick housekeeping items. As always, I'm sure someone in the audience today is wondering, is this session being recorded? And the answer is yes. Yes, it is. And we are going to post the recording as soon as we can so that you can come back and watch it anytime you want a little refresher. For those of you who want a copy of the slides, yes, those will be available as well. They are not available today, but we will post them along with the recording. Typically, the recordings are posted on YouTube as well as on the event page. So if you ever want to come back and look at a previous USPTO hour, just go to the event page for that USPTO hour session. If there's a recording, you'll see it there. If there's access to the slides, you'll see a link there as well. So if you are a person who wants or needs captions, you have a couple of options today. If you are okay with robot captions, you can just hit the little CC button down in the bottom left-hand corner of your screen. But if you are someone who wants live captions, human-generated captions, you're going to find that in the chat box. So that's going to be down in the bottom right-hand corner of the screen. You're going to see a little chat bubble. You can go ahead and open that up if that's something that you want or need. Darcy, who's running the WebEx today, is going to be posting a link to the live captions in there. And also, if you have a technical issue with WebEx today, something's weird with the video, something's weird with the audio, you can message Darcy in the chat and he will do his best to get you sorted out. If you are someone who has a substantive question for today, you can ask that in the Q&A. So Darcy has turned on the Q&A. That should also be available down in the bottom right-hand corner of your screen. Look for three little dots, hit those dots, and you should see an option for the Q&A, and you can ask your questions. But I will say, we're going to be mostly, well, the entire time, we're going to be focused on the presentation and our conversation about the role of an examining attorney. So we're not actually going to be in the Q&A, and so there will not be any sort of live back and forth with you inside the Q&A today. But instead, what we want to do is collect all the questions that you have, sort through them. If we have time before the end of today's presentation, I'm going to try to pull out a couple of ones that would be beneficial for the entire audience today, and I'm going to ask our panelists to answer them live on the air. I cannot guarantee that we're going to get to everything. In fact, I can guarantee you we're not going to be able to get to every single question that you might ask today. So please, if you're a person who submits a question and we don't have an opportunity to answer it, please don't take it personally. Chances are it's a volume issue, or it could also be an issue where you're asking for legal advice, and that is not something that we can provide. If you have a question that requires legal advice, we always recommend you work with an experienced U.S. licensed trademark attorney to help you out. But we will do our best to cover everything that we can. In fact, we had some questions that were submitted in advance. We tried to work some of the answers into the slide presentation today, so we couldn't answer everything that came in via email, but we tried to answer some of the more general questions as part of our presentation today. All right. Well, that is enough housekeeping. So let's get going. And it is my privilege to introduce our speakers for today. We have Christine Cooper, who is the Acting Deputy Commissioner for Trademark Operations, where she oversees the law offices, for examining attorneys, as well as the pre-exam unit, the Madrid processing, examination support, intent to use, and post-registration units in all aspects of trademark examination and registration. She joined the USPTO as a trademark examining attorney, and since then has served in a bunch of different roles, such as a senior supervisory attorney, managing attorney, trademarks chief of staff to two different, at this point, former trademark commissioners, and then eventually became a group director of the trademark law offices. She earned her JD from George Mason University Law School and a Bachelor of Business Administration from James Madison University. We also have with us Joanna Fiorelli. She has been a senior attorney since 2022, where she helped supervise a law office of 26 trademark examining attorneys. And prior to that role, as a senior attorney, she was a trademark examining attorney for 9 years, and she received her JD from the University of North Carolina. All right. Well, I'm going to start us off here on our conversation with a really quick review of what we're going to cover, and then we're going to dive into the role of a trademark examining attorney. So as you can see, we're pretty busy today. We're going to hit some real quick notes on background, just to sort of establish the foundation. We're going to talk about the overall general duties of a trademark examining attorney. Then we're going to go into the day-to-day. What is life like for an examining attorney when they're examining your applications? We're going to hit some numbers, talking about ratings, talking about metrics. We're going to cover hiring and whether or not we are hiring and what it would look like if you wanted to apply to become a trademark examining attorney. We have some common questions that we wanted to answer, and then hopefully we'll have time to get to some of your questions that you're submitting through the Q&A. All right, so let's hit some background real quick. I'm going to hand it off to Christine here in just a second, but just for those of you who may be new to this. Now, I know there's over 1,000 of you who registered for today, and probably most of you are longtime trademark folks who've been working with our office for a while. But we also know that there are some of you who are new to this, who are saying, yeah, somebody told me I needed to patent the trademark on my copyright or copyright the patent on my trademark. And you might be approaching this from the point of view of what in the world is this agency and what is it that you guys do? So in general, the responsibilities of the United States Patent and Trademark Office is that we grant patents and register trademarks, as well as advise the administration through our director who works with the Secretary of Commerce. We advise the administration on intellectual property policy and matters. And that will come into play a little bit later on when we talk about name, image, and likeness, which is one of the more common questions that we seem to be hearing these days. As you can see, the mission of our agency is to drive U.S. innovation and global competitiveness for the benefit of all Americans. So that's the overall of what our agency does, grant patents, register trademarks. But today we're going to focus on a very specific subset of those overall responsibilities, and that is the registration of trademarks. So brand names, slogans, logos, and other indicators of source. So Christine, welcome. I'm going to turn the talking over to you.
Okay, great. Thank you, Jason, and welcome everyone. So as Jason mentioned, the mission of the USPTO is to register trademarks, and we want to register any trademark that is eligible for registration. We know that timely service is important to our applicants and stakeholders, and our goal is to provide trademark owners with a federal registration that is legally sound, clearly defined, and reliable. And of course, the examination process helps determine whether a trademark is eligible for registration. But in addition to examination, I'll also point out that we do some other things. We maintain the Federal Register of Trademarks, we perform initial processing and preliminary examination of applications for registration, we issue trademark registrations, we offer search tools and information resources to provide notice to others of trademarks in use. We provide policy support by proposing and implementing new rules, and we interpret and apply trademark law and procedures. We disseminate information to the general public to raise awareness of intellectual property issues and to help ensure that entrepreneurs and small business owners are more informed brand owners overall, with a better understanding of the benefits of federal registration. And just a fun fact, some of you may know this, but currently there are around 3.6 million active U.S. trademark registrations.
Pretty amazing. That many these days. I think over the sort of lifetime, we've had like 12 million applications and registrations. So, and that's since like the late 1880s or 1880 and around there. So the fact that we still have between 3 and 4 million is pretty fantastic.
Pretty amazing.
Yeah. So Christine, one of the things I think is always important for people to understand, because I get this question a lot when I'm providing presentations, is why isn't it just I pay my money and then I get a registration certificate? And so I think it's important for people to see, in addition to these main responsibilities and everything that Christine was talking about, that's why. That's why it's not just here in the United States a process where pay a couple $100 and all of a sudden you have a certificate in hand, because there's all of this stuff that we are required to do.
Absolutely.
So let's talk about who does that stuff.
Yep. Okay. So this is a snapshot of our current staffing and trademarks. The trademarks organization makes up about 8.5% of the total USPTO. We have over 1,100 employees, of which around 70% are trademark examining attorneys. And I'll just note that with rare exception, the other attorney positions that are, some of them are listed here, but other attorney positions in the office, including Joanna's position, supervisory attorneys, staff attorneys, and the executive team are all former examining attorneys.
Yes. It's funny to see how examining attorneys end up, sort of branching out and doing other things for the agency, and all of it is grounded in this work that we do when we're first hired.
Absolutely. It's such a complex job, and it really helps to have that frontline experience and working with customers and understanding the law as you progress through the agency. So it is so helpful.
Yeah. Let's talk numbers. What are filings like?
Sure, sure. So this is a really quick look at our work. Last fiscal year, we received over 820,000 application classes, and we examined almost 924,000 classes. This fiscal year, we're on track to receive higher filings than last year, so we're staying very, very busy. But just to give you some context on what we mean by, we talk about classes a lot. Applications and registrations, for that matter, are tracked by classes they're in rather than simply the number of applications filed. Classes refer to the international classification system used for all goods and services. I'm sure many of you are familiar with that. The classes are assigned numbers of 1 to 45. And although there's only one mark in an application, it can be used on or in connection with goods or services in several different classes. And we refer to those as multi-class applications. For example, computers are in class 9, shirts are in class 25, retail store services are in class 35. An application that had all of these goods or services would be counted as a 3-class application. And that hopefully will give you some context as we talk a little bit more about examination.
Yeah, there's a lot of work that comes through the door, and I know we'll talk a little bit later about how much of that ends up on the examining attorney's plate. But seeing this difference here, Christine, between last fiscal year and what we're projecting, there's no guarantee we're going to hit that, but somewhere around there of 860,000. Historically, anything you'd like to tell the folks about how that has sort of tracked over the years from like the late 1990s all the way up to where we are these days?
Well, I just speaking very, very broadly, our filings increase somewhere between 5 and 10% a year, pretty steadily, with the exception of a couple of years in our past history where we were not at those levels. But you can pretty much reliably chart the growth, which I think is a reflection of the strength of our economy. But I will say, point out for people who have been practicing for a while or familiar with the trademark pendency, we did have right after COVID, we had a huge application filing surge. Our pendency jumped to about 8.5%. And we have been steadily ticking that down, chipping away at that backlog. We don't consider it a backlog anymore. We're down to more what we consider normal levels of inventory, and we'll talk about that, I think, a little bit later. But just to give you a little bit of context, we're really coming down off of significant efforts to get pendency down to our current levels.
Okay, great. All right. So let's turn it over to Joanna to talk about the duties of an examining attorney.
All right. Thanks, Jason. Yeah, so who is reviewing all of these applications that Christine just mentioned? Let's talk about that. Just a note, remember that the mission of the USPTO is to register any trademark that is eligible for registration. And trademark examining attorneys are public servants committed to that mission of serving the IP needs of America's innovation community. And this is the core business of what we do at the USPTO. So, with that in mind, the examining attorney's relationship with an applicant is really collaborative, not contentious. And examining attorneys carry out these goals by focusing on high quality and timely examination of applications. Next slide, please. Examining attorneys review trademark applications for federal compliance. They research and write correspondences to applicants on statutory and procedural issues. They work with applicants to correct informal defects in their application. They approve applications for publication and registrations, and they even sometimes draft appeal briefs and represent the USPTO before the Trademark Trial and Appeal Board. Next. So, what does that look like on a day-to-day basis? So, a typical day for the examining attorney involves pulling new cases into their examination docket and reviewing those cases. They also review any amended cases that come in from applicants. They work on any of their appeals to the TTAB, and they also participate in certain optional activities or special projects. And we'll talk about each of these in the following slides.
Yeah, it's really kind of interesting to look at this sort of list here because it seems pretty straightforward. You just do new, you do stuff that comes in, maybe you have an appeal, maybe do some other stuff. But and I know we're going to talk about this here in a little bit, Joanna, but like the actual day-to-day of what the examining attorney is like, this is broad strokes. Okay,
Yeah.
there is a lot that they are doing for each of these circumstances. So yeah, let's talk about new cases. What do we mean, and what are the examining attorneys doing when they pull a new case?
Yeah, so just some background on that. I mean, we have the Lanham Act, which requires that we register, like I said, all trademarks that are eligible and qualify registration. So marks, when we get them in as a new case, they can only be refused for cause, but that can range from really minor procedural issues like the wording for an identification requires some clarification, or to more problematic substantive refusals, such as when a mark is merely descriptive in relation to the goods or services, or refusals based on a proposed mark that doesn't even function as a trademark to consumers at all. So, unlike patent examiners, examining attorneys don't specialize in any one particular field, and this requires the ability to become a mini expert in nearly everything at some point or another in order to conduct the relevant research and make these informed decisions on these cases. So, on a day-to-day basis, examining attorneys, they'll request a case from their central electronic docket. It's the software that we use every day. And then they'll conduct a review of each of these applications. And the subject matter varies tremendously. You may pull an application related to clothing or cosmetics or nuclear reactors, publishing services, propane tank painting, and restaurants, all in one given day. The basic underlying steps of examination, though, are the same for each one. You make sure the procedural matters are in order, you review the ID, you conduct a search, you likely research the mark to see what it really means, but the knowledge you need or that you need to obtain for each one varies tremendously. And I know for a lot of examining attorneys, this is one of the best parts of the job because it gives you the chance to learn something about everything and be exposed to such a broad range of fields, much broader than many jobs offer.
I know that's true. I started many years ago, and when I first started, law offices did have sort of not specialties like an art unit in patents or something, but there were specific classes that we typically would examine. Mine were classes 6, 7, 8, 13, 15, and 12 and and things like that. And so I was getting a lot of cases that were all about metal goods and hand tools and power tools and vehicles and things like that. But eventually that did switch And so it became everybody examines everything. And it was really fascinating as an examining attorney. I know that I certainly learned more about a lot of different things because I had more exposure to them than I did when I was slightly more focused on those specific things. So it's really kind of interesting because certainly as you see more cases come across your desk, you begin to understand interconnection between different industries that you might not have seen had you been so hyper focused on one.
Exactly. Yep. You have the chance to learn so much about so many different things all during your day-to-day job. And what's really great too is the more exposure you have to different trademarks, the higher chance you have of seeing those trademarks in the wild, which is really fun when you see something you've worked on as you're, driving down the road on a billboard. So it's pretty cool.
Yes, absolutely.
Yeah.
I think it's interesting too as you learn more. It's an opportunity for the applicants to educate us as examining attorneys on what particular terms mean and what is going on in an industry, which becomes even more helpful as you examine more and more. You have a deeper knowledge across a larger scope, and a lot of it is driven by the responses to office actions that applicants or their attorneys will submit.
Exactly. Yeah. Which is a great segue into the next slide, where we're going to talk about these amended cases. So, often examining attorneys, they'll work on what we call amended cases. And this is the situation where the examining attorney has done everything we talked about in the last slide. They've reviewed the new case, they've done the research, they've reviewed the application, issued a communication to the applicant indicating why their application was refused or what procedural issues need to be corrected. And now the applicant has responded. So once we receive that response, and the applicant has either submitted arguments against the refusal of their application, or they've responded with any corrections that may be necessary before we can approve it, once we receive that, then we can take a look and see if all of the issues that were raised in the office action have been resolved. If not, then the examining attorney will write or call the applicant to let them know what issues remain, if there's anything we may be able to fix on our end, or they'll write to them if they need to respond one more time. If everything looks good, though, they'll approve that application for publication. So these are the amended cases, and we generally expect examining attorneys to take action on these cases within 28 days.
Yeah, that's not like a firm 28. I mean, like that's
Yeah.
the expectation. And I think one of the things that's also interesting here too, and you can talk about this too, Joanna, is like the amount of work that the examining attorney is doing at this stage of examination sometimes expands exponentially because you are doing more research. Sometimes the office action is going to be longer if it's going to be that final office action. So there's more that's happening during this period of time.
Yeah, I mean, I once received an amended case with a response that was around 500 pages.
Oh
So
my goodness.
that probably took me a little more than 28 days. So, it can really vary.
Yeah. But I will say the joy that I would always feel when an applicant responded in the response to an office action with something that cleared up all of the issues and they were all taken care of, or I was able to withdraw the refusal and I could approve it for publication. That's what we all want as examining attorneys. Is we want to be able to move that application along. And no one's looking to write refusals. At least I never did. So
Yeah, exactly.
So let's talk about the TTAB.
Yeah. So sometimes, like I said before, the decisions of examining attorneys will be appealed to the Trademark Trial and Appeal Board. And in this case, examining attorneys are expected to draft that appeal brief that goes to the TTAB and potentially make an oral argument before the TTAB should the applicant request one. So that's a fun element of the job if it's something that interests you.
Yeah, and it's kind of interesting to see as well how often these things happen because I know when I was examining, I didn't have very many appeals, but I'm well aware of other examining attorneys who have a lot of them,
Yeah.
and sometimes that's just the way the facts fall, and whether you're going to have to write an appeal or even do those oral arguments. I only had one oral argument during my time as an examining attorney, but I know others have had more. I don't know about what yours was like, Joanna.
You know, I never had an oral argument, but I did have many briefs that I had to write. I do have some employees that have many more.
Yeah.
So yeah, it just depends on, the kind of case you get and if they get appealed. But it is fun to watch, I will say. It is
Yeah.
fun to watch those oral arguments.
Yeah. Absolutely.
Some people love doing them. I
Yeah.
mean, I know there are examining attorneys who volunteer to take someone else's appeal so that they could do the oral argument.
Yep.
They find that really fun.
Yeah.
All right. Well, speaking of fun, what else is going on during an examining attorney's day? What else could they
Right.
could they do?
So we have a number of optional activities and special projects that our examining attorneys participate in. For example, they can prepare and present legal case summaries and examination tips to share with their colleagues. That's always super useful for everyone in the office. They can volunteer to mentor a new attorney, whether that's through our formal mentorship program, which involves reviewing the work of recent hires, or through the informal buddy program where they can help our new hires navigate life here at the PTO. We also have work projects and details like volunteering to help with the combined federal campaign and volunteering to help with PTO Day, which is coming up, or assisting with special kinds of trademark applications that involve specialized knowledge on certain subjects. So definitely different opportunities that folks can get involved in here at the PTO that makes the job very enjoyable.
That's right.
Mhm.
All right. So we've talked about what the examining attorney does on a very high level. Let's talk about what they don't do.
Yeah. So, what the examining attorney does not do. So, here at the USPTO, they cannot provide legal advice or represent applicants, and we've kind of touched on that already. They cannot recommend specific private attorneys. Sometimes we'll include a link to a bar association to help, but yeah, we cannot provide that kind of information. They will also never charge the applicant for their services, and we'll talk more about that when we talk about scams.
Mhm.
They cannot speak to an applicant that is represented by an attorney. All communications must go through that licensed attorney. And they cannot withdraw your attorney representation for you. That will have to be done through your My USPTO account.
That's right. And these are a lot of questions that we see on a pretty regular basis.
Mhm.
And so we always try to make clear no one at the USPTO can provide you with legal advice. We have our Trademark Assistance Center, which are our customer service folks who are able to provide information and point you to resources and things like that, but they cannot provide legal advice. Or anyone who happens to be writing in a question today, I'm not looking at them, so I'm not seeing, but I know in some of the training that we do, we have people who, they're not specifically trying to get legal advice for free. They're trying to figure out a situation. It's not something where we can provide that. And sometimes when, as an examining attorney, you would hear from people who were an unrepresented applicant and they're trying to get you to advise them on well, what should I do in this situation? And that's not something that the examining attorney can do. And yes, I want to highlight, we'll absolutely talk about that, Joanna, when we talk about scams, charging for services. I certainly hear that question as well. Hey, the examining attorney says they are going to or people think they cannot call their examining attorney because the examining attorney is going to bill them for time. Nope, that's not how it works. Your filing fee pays for the examination of your trademark. We don't charge you for any sort of service like that.
Mhm.
So, all right, well let's okay. That was high level. All right, let's dive into some day-to-day and maybe sort of take us through like what is it that an examining attorney is going to be staring at all day long on their computer screen?
Yeah, so this is kind of fun. I like this slide because it gives you a sneak peek into, like Jason said, what we see on our screen every single day. So when we review a case, whether it's a new or an amended case, all the documents and case contents will appear on what you see here on your screen. So on the left, you'll see everything that's been submitted by the applicant or from the office. And then the contents of each of those documents will open on the right, and that's where we can see, what's going on in that specific document. So as you can see here, we have some information about the case, some high-level information. We have the serial number, the filing date, the mark on the right. And if we open each of those gray tabs that you see on the bottom right, we can see the identification of goods and services, the owner information, etc. So this is pretty similar if you're used to seeing things on TSDR. It's pretty similar to when you see the what do I call that? Like the not the case contents, but just
Yeah.
the general file when you first open it. So that's what we see here.
And by the way, folks, what you see on the screen is actually fairly new. I don't know, Christine or Joanna, how many years Team Exam has been in existence? 2 or 3, maybe somewhere around there.
Maybe, yeah, around 3-ish.
Yeah. Before that, it was in many ways sort of they were standalone systems, and they sort of built a sort of frame around it to try to put things together. And so what you see on the screen is a much more efficient way for the examining attorneys to do their job. We're, as an agency, we're always looking for those efficiencies. How can we make things go faster and still have high quality? And so this is one of those approaches that the office is taking, is creating a more streamlined system for examination.
Yep, absolutely. And I'll just mention that this is a web-based system, and we really are trying to and have incorporated tools into this interface, so that we don't have to, examining attorneys don't have to go out and grab 10 different tools to be able to do the job inside of TM Exam. But always looking to improve the internal system.
Yes. All right, well, let's talk about another internal system.
Yeah. So after examining attorneys review their case contents, you've heard me talk about how we generally search the mark to ensure that there's no likelihood of confusion with a registered mark. And here you can see that our examining attorney has begun their search by typing in some relevant terms like patent and a truncated form of the word trademark. And the search may continue on from there to include variations of the letters as an acronym, and maybe even the letters PTO in conjunction with a design code of rectangles with rounded corners. And what's really great is that this is the exact same database as our public search, even down to the keystrokes and the syntax that we use if you're using search tags in that public search. It's just a different interface, but in essence, we are seeing the same things that the public is searching.
And that is a common question as well, Joanna, is people will say, well, are you guys looking at something different? Or, nope, it's the exact same stuff. There's, it's the same thing that everybody's searching. And obviously, as you say, the interface is different. So the public interface just has a different way of interacting with it, but those keystrokes are all the same. Now, the examining attorneys do use a more advanced form of searching that's called regular expression searching. You folks as well are welcome to use that too. We typically don't talk about it a whole lot or teach it because it is slightly more advanced, and unless you're someone who is probably a programmer and is used to regular expressions, when you first encounter it, you're like, what is happening here? But for those of you who are more seasoned trademark professionals, you might remember our old public search system called TESS, and all the same sorts of searches that you used to do in TESS, you're able to do in the public version, or actually in our new version of the search system. It's just a different way of doing it. So just keep that in mind. And there's nothing special about the way that the examining attorneys search. It's the exact same way that you folks search as well.
Yeah.
All right, so go ahead, Joanna. Let's talk about what's going on in this screenshot.
Yeah, so unfortunately, this applicant has some issues, right? So we need to write an office action. This is the formal communication that is sent to the applicant. And this is exactly what it looks like. We have a pretty straightforward word processing software that examining attorneys use to draft these office actions and attach any evidence that they may have to support their refusals. And that's what it looks like.
Yeah, pretty straightforward, nothing super fancy.
Mm-hmm.
Okay, well, let's talk about those sort of procedural issues. I mean, I think different examining attorneys approach things differently. I know when I examined, I typically would look at the procedural issues first before substantive issues, but I'm sure there are also examiners who hit the substantive stuff first before they get into the nitty gritty of procedural. So let's talk procedural stuff. What are really people, examining attorneys, looking at? What are some of the main things anyway?
Well, I will say that procedural issues are the best kinds of issues an applicant can have because they can often be easily corrected. And some common procedural issues that we often see are where there's a mismatch between the applicant's name and the entity. So if the applicant's name is ABC Incorporated, which signals to us that this is a corporation, but the business entity is identified as a limited liability company, that inconsistency will have to be clarified by the applicant. It's something we see pretty often here. Some other issues include unacceptable drawings of the mark if it's illegible or it includes a trademark registration symbol in there. Another situation is where the goods and services are indefinite, so they've been identified probably in an overly vague or broad manner. We also see that marks are not described with enough specificity, or we may have the situation where we need to ask the applicant to disclaim wording in the mark, which is to indicate that they don't claim ownership of a specific word in the mark because it's so descriptive that other folks in the industry may need to use this word in their marks to describe their own goods and services. So those are just some of the kinds of things we see on a daily basis.
Great. Well, I know we're going to dive into drawings just as an example here, but I would highlight my understanding is we're seeing less some of the issues with goods and services these days because of the base application that is now available in Trademark Center. And the fact that because of the fee rule change, it does cost more to draft your own listing of goods and services. And I know our attorney friends out there still want the ability to draft their own, but we've actually seen, I think, a decrease in the numbers of people who are submitting those customized goods and services, which also decreases examination time because if you're pulling listings that are that you know are acceptable out of our ID manual, then there won't be as many indefinite goods and services description issues. So just a little pro tip for folks as a way to keep your costs down and also maybe partially speed up the examination of your application. So let's talk drawings, Joanna. Let's talk about some practice points for the folks.
Yeah, so I'm going to invite you all to go into the mind of an examining attorney. Let's pretend that they're reviewing the drawing in an application. And these are the sorts of practice points that they're going to consider. So it's important to note first that drawings can be separated into two categories. We have the standard character drawing and the special form drawing. And a standard character drawing means that there's no claim to any specific color, design, or stylization. In this case, typically there's no mark description, and only standard characters are permitted. So no specialized characters like superscript, subscripts, or exponents are permitted. And standard characters that are formatted to create a design like an emoticon, those are also not permitted.
And so what would people do instead if they had something that was more of an emoticon?
Yeah, so if they had something like that, then we're going to choose the special form drawing because this can include designs. Here you can claim specific stylization or font and sometimes include a claim to particular colors in the mark. With special form drawings, you need to describe all the significant elements of the design in the mark description field of the application. And we also need to specify all the colors in the mark, if there are any, in the color claim field of the application. And the mark description must indicate where these colors are located. Also, just to note that drawings cannot include registration symbols, which is the R in the circle, or the common law trademark and service mark symbols, which are the TM and the SM. And we also want to note that you can't include registered marks in your mark description. So if your mark contains, for example, a popsicle design, well, the word popsicle is actually a registered mark. So you have to say something like, it's a frozen treat on a stick. And a lot of font types are also registered marks, so you can just say that the wording is in a stylized font rather than naming that specific font you used.
Let's take a look at an example of that.
Yeah, so let's apply. I know that was a lot of information about drawings, but let's apply that to this case. So here we have a special form drawing that our examining attorney is looking at, and it's considered special form because it's in a particular stylized font. So an acceptable mark description here could be very simple. The mark consists of the stylized wording T-dot marquee. So that's what we would do here in this case. But let's move on to something just a tiny bit more complex, which is the same mark, but in color. So not only will we need a mark description, but we'll also need a color claim identifying all the colors in the mark. And we'll need that mark description to indicate where the colors are located in the mark. So the mark is still T-dot marquee, and the color claim states that the colors are orange, blue, and black. And then in the mark description section, we've indicated the same mark description as the previous example, but we're adding the fact that this mark is in orange with a blue and black outline.
And just want to point this out because we sometimes get a question from people like, oh, do I have to put in the hex code or the Pantone color? Like, how specific does my color need to be? You want to talk about the example you see here?
Yeah, so generic colors are perfectly acceptable, probably preferred, I would say. So, you don't have to go crazy with identifying the shade or the hex number. As long as you give us those generic color names, that's fine.
That's right. I will say it does get a little tricky when it is a color drawing that has multiple variations of color in it. I distinctly remember one case where I was like light blue, sky blue, aqua blue, royal blue, because they had all these different shades of blue in it.
Yep.
Most trademarks drawings aren't that way, but sometimes they are. And of course, the other thing too is that, remember, you do not have to submit a color version of your drawing. Oftentimes, as you longtime practitioners know, there's more value in submitting a trademark that with no color claim to give yourself that flexibility over the life of the trademark registration. Okay, I'm looking at the clock, Joanna. We have about 19 minutes left, so let's keep on rolling and let's talk about some substantive things that examining attorneys are going to look at.
Right. So some common substantive issues that we see are the likelihood of confusion refusal issues, descriptiveness and geographic descriptiveness of the mark, certain specimen-based refusals, like when the mark is shown on the specimen in such a way that it fails to function as an indicator of source. And that can be something like where the mark is just an ornamental design or phrase on the front of a t-shirt. It's not really a trademark, or it's just informational matter found on packaging like net weight or nutritional contents.
Well, let's talk about the most common one. I mean, I think we see a lot of descriptiveness refusals, but let's talk about likelihood of confusion and what that really sort of means and what's going through the examining attorney's mind. Are they looking at all 13 DuPont factors?
No. We generally look at two main considerations, which are the first being that the trademarks are confusingly similar. Is there shared wording? Do they look different but maybe sound the same? Do they have the same meaning or commercial impression? And then we're also looking at the goods and services to determine if they're related. So if, for example, we were trying to determine if two products are related, we may want to see if there's evidence that the same companies manufacture both products and market them under the same trademark, or that these products are sold in the same kinds of stores, or that the products have the same kind of purpose or function. So all those kinds of things we're considering when we're determining whether there's relatedness between the goods and services.
And remember, it is always fact and evidence specific, folks.
Yeah.
Sometimes we get questions from people who say, oh, but I registered mine in this class. Somebody registered in that class. They're fine, right? They're these separate silos. No, that is not how that works. As you can see on the screen, the test is not, are they in the same class or are they in different classes? The question is, are the goods or services related? And that is a different sort of analysis. And again, remember, folks, it's an analysis that you can do as well. It's not just the examining attorney, and you can run that analysis before you actually file. So what else are they thinking about besides these two main things? I know there's some other stuff that comes into play.
Yeah, so we're considering things like how distinctive the marks are. So usually a stronger term in the registered mark, if there's a stronger term in the registered mark and it's shared with that same term in the applied for mark, it's more likely that there's going to be confusion. They're also looking to see if the applicant's mark is just another way of referencing the registrant's mark. So are we comparing the word delta with a delta symbol? Or the marks may look different but sound the same. So are we comparing the word fat, F-A-T, and fat, P-H-A-T? Those we would consider to be confusingly similar. It's also important to note that what is the dominant portion of the mark? And that can be the term that's first in the mark because it's what most people will remember. It can be the stronger or distinctive word if the remaining words are weak and descriptive. Or it can simply be the element that's largest in size. And if the dominant portion of the marks is the same, we may consider the marks to be confusingly similar regardless of the differences in the marks. And I'll also highlight that we will issue a likelihood of confusion refusal where the owner's names are very similar but not identical. So if you own a similar registered mark and that registration does not have the identical owner name, citizenship, and business entity as your application, we'll issue that refusal if it's warranted. And of course, that can be corrected, but it's something to look out for.
Yes. All right. Well, let's talk about some examples here.
Yeah.
Talk about a couple of fairly recent cases anyway.
Yeah, this first one, it's fun to say. The applicant's mark is glitterally perfect for eyeshadow and eyeliner, and then we have glitterally obsessed for various glitter cosmetic products. And in this case, the TTAB agreed with the examining attorney that the marks are confusingly similar because of that shared dominant term glitterally, which is both conceptually strong, it's a fanciful made-up term, and it's commercially strong because there aren't many others using it in the industry. And they agreed that the goods were related based on the evidence that the examining attorney offered, which was that retailers are selling both of these products under the same mark. And they noted that the goods provide similar functions as well.
Okay, let's do another example.
Yep. All right, this one is also fun. We can look at this. The marks are triple eye and third eye, both for very similar types of cameras. And this case went a little differently. You can see that there are some notable similarities in the marks. However, the meaning or the commercial impression is different in these marks because, as we know, the third eye isn't just referencing an additional eye. It's a well-known spiritual or religious meaning, right? So in this case, the TTAB decided that there was no likelihood of confusion because the marks as a whole mean completely different things.
And I think this is just such a key point to highlight for people as well, is that the likelihood of confusion analysis is not mechanical. It isn't if this, then this every single time. There are so many just different shades and subtleties that go into the analysis, which is why it can be very difficult even before you apply to register your trademark to kind of figure this out. And it's difficult for the examining attorneys as well as they go through the analysis. There's a lot. It isn't like, uh-oh, this, okay, refusal or good to go. There's a lot of research that goes into it, a lot of reasoning that our folks are doing before they actually take a decision or make a decision in a case.
Yeah.
Okay, let's hit some practice points.
Yeah. So I'm actually just going to touch on a couple of these just so we can move on to a few other things. I want to point out that probably some more important practice points here on this list are, like we mentioned, the goods and services don't need to be identical or even competitive to find a likelihood of confusion. We just need there to be evidence that they're related. We're also looking at whether consumers will be confused as to the source of the goods or services, who's manufacturing it, who's producing it, who's offering the services. And we talk about the consumer being confused a lot. Well, who is this consumer? We're talking about the average consumer, not just how you or your neighbors see the relatedness of the goods or services, but who is the average consumer? For clothing, that's going to be everyone. Everyone has to shop for clothes, right? But for more sophisticated goods, like specialized medical equipment, then the relevant consumer will be more narrow. So we're looking at the folks who are purchasing or using these goods or services. So we can move on.
Okay.
The next slide.
And yeah, I'm looking at the clock as well. We only have 11 minutes. So
Yeah.
I'm not saying you have to rush, Joanna, but.
Okay. And I think in this slide, I will probably focus on my favorite, less persuasive argument, which is that my customers are sophisticated, and they probably are. But just to note that the fact that purchasers are sophisticated or knowledgeable in a particular field does not necessarily mean that they are sophisticated or knowledgeable in the field of trademarks or immune from source confusion. So this is a typical argument that we get that's not as persuasive as some others. Are there any on here, Jason, that you think we should point out as well?
Well, we already talked about the fact that the goods and services are not in my class.
Yeah.
That is one that we certainly hear from people as well. And I think really in some ways the takeaway is, how are the goods and services listed in your application, and how are they listed in the registration? Because that is obviously something that people say, but yeah, but they're actually not doing that for the same people that we're doing this for. Well, the registration cannot be sort of cinched down in that way. The ID is the ID, and so we have to assume that all of those products or services are being provided for all people unless it says otherwise. So.
Exactly.
All right, we have about 10 minutes left. So Christine, let's bring you back here into this conversation and make sure that we're keep moving here and talking about ratings and metrics, because this is absolutely, again, we couldn't answer every question that was submitted in advance, but this will hopefully answer some of the questions submitted by one of you with questions about, how do we know what these examining attorneys are doing? Are there ways that we rate them? And so Christine, if you could talk about this.
Sure. So each fiscal year, all of our employees receive a performance appraisal plan that lays out specific and measurable goals through what we call performance elements. The examining attorney performance plans have two primary performance elements, and those are quantity of work and quality. So we call quantity, or refer to quantity as production, so production and quality. In addition, their plans have elements on docket management, which could include things like taking timely action on their cases, and a customer service and professionalism element, which could include things that you'd probably guess, basic office expectations like returning phone calls in a timely manner and attending your office trainings and meetings. And apart from some basic parameters like working during the business day, primarily during the business day, and not working when systems are undergoing scheduled maintenance, there really is no prescribed way for examining attorneys to get their work done. And knowing their goals at the start of the fiscal year really allows them to develop their own plan to hit their targets.
All right, well, let's talk numbers here for production.
Sure. So again, two primary performance elements for examining attorneys are production and quality. The examining attorney production goals are set for the year with interim goals at the end of each quarter. And as you would expect, less experienced examining attorneys have lower goals, and production goals are then progressively higher as the examining attorney meets specific milestones that demonstrate their ability and broad expertise. We measure productivity through what we refer to as a balanced disposal, or a BD for short. This is essentially a credit for work done. For each class examined in an application, the examining attorney will earn one balanced disposal, or BD, for the first action taken on an application, and one BD for the final action taken on an application. Typically, the first BD is earned on a non-final office action, and the second BD is earned on an approval for publication, or if the application is abandoned. We set production goals that help us meet our organizational pendency targets, and we measure pendency in the organization in two ways. And that's the chart you'll see on the slide. First action pendency is the time it takes from the application filing until the first action is taken, and disposal pendency is the total amount of time it takes for an application to make its way through the entire examination process. And you can see in the chart that our first action pendency goal is 5 months, and disposal pendency goal is 11 months. That is for this fiscal year. And I'm happy to say that we're currently under both those numbers, which is a good thing right now. And then just an interesting fact, an examining attorney handles around 1,000 BDs per year, or processes about around 1,000 BDs per year credits. And last fiscal year as a group, we produced over 1.85 million BDs. And that is a lot of work.
Yes, it is. I know we have to keep moving, but I will just let me ask you this, Christine, because sometimes people say, "Why am I getting all these office actions?" Right? Do they get credit for every single time they send me a letter or call me or whatever? Is that true?
No, absolutely not. We
Right.
really want to work as efficiently as possible. And so if you're getting another letter, it's that hopefully is the exception and not the rule.
Exactly. Examining attorneys do not want to keep sending you stuff. They want to approve your application for publication.
Absolutely.
All right, let's talk performance and quality.
So sure. So when we talk about quality and examination, we're referring to a few things. We're talking about the identification of all the issues, including substantive refusals and procedural requirements, having a sufficient search strategy, the accuracy of decision making on a file, and then well-supported refusals and requirements that are presented in a clear and concise letter or office action. Examining attorneys may be evaluated on first actions, subsequent non-finals, which we hope are rare, final actions, and approvals for publication. And the organization is evaluated on 2 quality metrics, first action and final disposal quality. Quality review itself is performed both within the law office by people like Joanna, by the managing or senior attorney in the law office, and outside the law office by our special unit or quality review unit. The quality review results are then used to both take corrective action on files as well as opportunities for targeted training. And you can see in our chart that our first action quality goal is 95.5%, and our final action quality goal is 97%. That is for this fiscal year, but it has been those have been the numbers for quite a while now. And this essentially means that we want at least 95.5% of our first action work and 97% of our final action work to be accurate and without error. And I'm happy to say again, so far so good. We have phenomenal examining attorneys.
Yes. All right. Well, speaking of examining attorneys, and Joanna, we will have to move quickly because I do want to hit a couple of questions. So let's talk hiring very quickly
Yeah.
and how that works.
So I'll first say that we don't have any open positions at the moment, so you'd have to wait for the next hiring cycle. But generally, we're trying to fill the GS11 attorney advisor position, which is entry level, and it's for those that have graduated from law school and have an active bar membership. Then sometimes we open it up to the GS9 law clerk position, which is not an internship position. This is full-time permanent attorney position for those that are have pending bar admission, and those will be promoted directly to GS11 position upon that bar admission, as long as it's within 14 months of being hired.
All right.
Additional requirements: you need to be a U.S. citizen, have your JD or LLM, bar membership if you're applying for a GS11 position, selective service, and you must be suitable for federal employment. And then applying is very easy. Positions are always announced on usajobs.gov. I would suggest creating an account on the website and set up notifications for future job announcements using the keyword trademark. And what's cool about this site is you can upload your resume, your cover letter, your transcript, and it will save those documents for you for the future if you so desire to keep them there. And then I finally want to point out our Become a Trademark Examining Attorney page on the USPTO website. Ton of great resources here that talks about what it's like to be an examiner, what kinds of benefits we get, how to apply. So if you're interested, please check it out. We've included the link and the QR code there on the screen for your convenience.
Yes. Real quick here, photos of some of our fine folks here at the agency, life at headquarters, whether it's working in their offices or various community things that happen at headquarters. So All right, so we have 2 minutes left. So real quick, let's hit some common questions. Christine, you want to talk very briefly because we get the
Yeah.
question, but what about AI?
Yes, happy to. So we are really leaning in when it comes to AI. We're exploring ways to use AI to detect fraud on the office and also to help applicants file more complete application at filing. Jason referred to that earlier. We're testing AI in examination currently with a large language model for research, but we're also exploring the use of AI to assist the examining attorney in other areas of examination. And I'll just say this is a very exciting time for us, and we'll look forward to sharing more in this area as things progress.
Okay. So I'll take this one. What about name, image, and likeness? We've been hearing this one more, and I know it's a priority of our director and of the agency. A lot of things have been happening in this space, and so one of the main takeaways here is name, image, likeness is really about you being able to protect your name, image, likeness. And so one of the ways you can do that is through federal trademark registration, specifically if you are using your name, image, likeness as an indicator of source. Because remember, we register trademarks, and in order to be registered, it has to be a trademark. So the fact that your name, image, and likeness is something that you were using to indicate the source of your products and services, hey, that's potentially something that can be registered with our agency. There are obviously all sorts of things that are happening now, whether it's generative AI and all sorts of different things. And so we know that people are looking for ways to help protect themselves. And so our agency is positioning itself as an advisor to the administration on intellectual property issues to be a leader in this space. And so look for our agency to be talking more about NIL and ways that people can protect themselves, whether they're student athletes or celebrities or other folks who are using their name, image, likeness as indicators of source. All right, we are technically at time, Joanna, but could you talk briefly about scams because it is a major issue?
Sure. Yeah. So we're definitely dedicated to identifying scams and fraudulent activity that involves a USPTO. I'll say that we've developed systems to protect trademark owners from fraud, and we've worked to investigate situations that have affected applicants. We have a great trademark scams page on the USPTO website. I think that's what Jason is pulling up right now. Yep. And it provides information on common scams and tools that help you protect your trademark. And there are a few things that you can do to prevent, from becoming a victim of a TM scam. And that is first, check TSDR to verify information and deadlines. All formal communications will be posted there. Also, we will never ask for personal identifying information. Do not give your social security number to anyone claiming to be from the USPTO, and only pay for trademark fees via our electronic filing system. We will never ask for money over the phone or via email. And if you unfortunately become a victim of a scam, you can report this to tmscams@uspto.gov with any relevant evidence and attachments. And we have a number of other suggestions listed on the page as well that you can check out.
Okay, and I just threw some stuff into the chat. So if you want the link to get to this Protect Against Trademark Scams page, look for that in the chat. I also included a note with the email address tmscams@uspto.gov. That's where our dedicated scams folks are going live. Actually, they spend a lot of their time in that mailbox looking at what you are sending in and trying to help identify scams so we can raise awareness to help you so that you can avoid those situations. I know that we are 2 minutes over and Darcy's going to cut us off really, really soon. But one thing that I wanted to note is that we received a question in advance from a longtime practitioner who said, hey, I'm suddenly getting these emails from examining attorneys, advising me that my clients' applications, which have long been abandoned, could potentially be brought back to life. Are you guys doing this? And I don't know, Joanna, you want to answer that one?
Yeah, that is not something our examining attorneys do. If there is an in-flight application, meaning, it's an application that's been received that we're working on, then we may email the applicant or the attorney to see if there are certain small procedural issues we can correct on our end. But an application that has been abandoned and needs to be revived, that's not something that we will ever be involved with.
Correct. That is most likely going to be a trademark scam. And because, again, we don't provide advice, so we wouldn't say, hey, you want to bring it back to life? And also keep in mind, there are those date restrictions, technically 2 months after the notice of the of abandonment goes out. And actually the system, I believe, will not allow you to file petitions to revive after a certain period of time. So good eye out there for whoever the person was that emailed in about trademark scams. That is not us. We are not, our examining attorneys are not emailing you and suggesting that you bring dead applications back to life. All right, so we are 4 minutes over, and so Darcy is very soon going to pull the plug. But thank you very much, everybody, for being with us today. And thank you to Christine, to Joanna, and also to Darcy in the background for running the WebEx. Really appreciate your time today. I want to take you back to your lives and encourage you to please continue to sign up for USPTO events, whether it's USPTO Hour on Wednesdays or other programming that we might have. We always want to know what you have to say. And what your thoughts are. So we'll be taking a look at some of the questions that you perhaps submitted today during the presentation so we can maybe provide some more helpful information to you. So thank you very much, everybody, and take care.